Okay, our next case, Stephen Jeremy Robinson versus Jennifer Leah Robinson, consolidated case numbers 17-1109, 17-2427, and 18-1467. All right, counsel, whenever you're ready.
May it please the court, my name is Adam Sudbury. I represent the appellant Jeremy Robinson, and may I reserve 5 minutes for rebuttal.
Okay, very well. Thank you, counsel.
Your Honors, I'd like to give a very brief recitation of the facts because they are quite lengthy, but there are some...
Let me jump in. Let me see if I understand where exactly you're asking here. In the three cases, if I understand in your initial brief on 17-1109, you're not challenging the disposition of the 315507 of the medical expenses. You said that on page 18 of your brief, but you are arguing that the adjudication of him being in contempt was incorrect because the order that ordered him to pay the medical expenses was too vague for him to be subjected to contempt sanction.
That's correct.
All right, part one. So then, and then we go to the next case, 17-2427. There's actually two orders. Yes. One of them he stipulated, if I'm understanding the judge's order, he stipulated that, okay, I get it that I owe $72.46 for income tax return monies that apparently the ex-wife paid, and also the pre-2015 medical expenses. But the issue then becomes in the second order where he has a credit determined by the clerk of a $44.63.25 and alimony that was then applied prospectively as his child support came forward, and that the judge at some point said, well, we need to have figured this all out as to how this came about, but the judge said, but you don't get, the clerk doesn't get to do that, what the clerk did. You think that's erroneous determination by the clerk there. So you want that to be resolved. And then lastly, the clerk determined that, or the judge determined that there was a child support arrears as of February 27, 2017 of $69.3157, and that's really kind of premature until there's an accounting done as to what was paid and what he should have paid. Is that kind of a fair summary as to where we are?
All except for the last bit of it, Your Honor. The judge actually there was an accounting done, and that was part of the order in June 2017. Part of that order was the judge directed the clerk to conduct an accounting.
Right.
And then the accounting was conducted, and in the December 2017 hearing, the court judicially noticed the clerk's records. And it's in the December 2017 order. I think that order was, if it wasn't entered exactly at that time, but that hearing, the court does recite that it judicially noticed the clerk's records and acknowledged that the clerk was saying that he had a credit of $4,000 and change.
The December 13th, 2017 order?
Yes, Your Honor.
Isn't that the same order that found your client in contempt?
That's correct.
Okay.
Well, let me see if I'm big picture here. I mean, the alimony, I mean, we're talking about, we're going back in time now because his alimony obligation is now expired.
Correct.
Right? And if I'm understanding, the one child's now 20 and the one child, Emma, had turned 18, according to the records, as of February 16 of this year. So if we're assuming that she's went through high school and done with high school, so the finite amount of support and alimony your client was to have paid is determinable, right?
As of right now,
as of right now, we're not going forward. So
correct.
It seems to me then the scenario is we can go back to, I guess it was January 1, 2012 when the meter started running, for lack of a better term. Compute how much alimony, $300 times 54 months, I believe, and then $900 from that day until, I assume, June 1, right around when she graduated from high school. So that's a finite amount. And then, I mean, I didn't get anything in the record that he was making side payments to her directly. He was paying it through the depository. So what I'm getting to is there's a number that he should have paid. There's a number that he did pay. If there's a difference between that, that's what he still would owe, arguably towards child support arrearage. That should be a number. Now, whether he should be held in contempt, I get that's a different story. But to actually get back to square one for the benefit, because you want us to reverse and send it back, to get it back to the trial judge, that would seem to be the roadmap to say, okay, look, here's the number that is owed. Now, you decide whether this fella should be held in contempt or not at this point. You don't even have to go back to this, we don't even have to address the issue about whether you were entitled to give the prospective, you got a credit, because for whatever reason, at today's date, we're past all that, aren't we? Realistically?
We are, as a matter of this particular
As of today. If we
party.
were talking a year and a half ago, we wouldn't be, but today we are, right?
We are, as for this particular case, yes.
Sure.
Yes. It is certainly possible. I think in the record there is some factual dispute as to what payments may have been made prior to the State Disbursement Unit getting involved. There's a period of, I think, January 2012 to August 2012. There's some reflection of payments, but then the State Disbursement Unit gets involved. But that amount, if it were, it doesn't account for the over $10,000 in discrepancy between what the former wife is saying and what the clerk's records reflect.
Well, with that lay of the land that I didn't try to steal your thunder, but with that lay of the land, just so I'm getting understanding, what is it you think, I get you want us to not have him found in contempt, we'll get past that, I understand that.
A lot of ramifications to...
I get all that, all right, and so let's assume for the sake of our discussion today, that's what we do. We nullify any findings of contempt. And then the pragmatic thing is, okay, does he still owe money from back then, as a few months ago? And what is that amount? And then everybody can go forward with the trial judge, theoretically, one last time and say, this is the number you owe, pay up. And then are you not paying because you were in contempt, because you can write a check today or you can't? And then the trial judge can make determinations from that point.
I think the court should be concerned about the procedure in this case and the...
Yeah, but there's also a body of law that basically says we don't make advisory opinions. We may see scenarios that we might not have liked, but we're past all that now. Kind of analogize to, okay, if somebody gets an illegal sentence but they served it, we don't go back and correct the illegal sentence because it's all done. If the judge shouldn't have done what he or she did, but now we're at a point where we can say, this is the number he should have paid, this is the number he did pay, he owes the difference here, go back and, pay it up or work it out or something like that. We don't have to give advisory opinions about whether judges should or shouldn't do what this judge did vis-a-vis applying the alimony credit towards prospective child support.
Well, Your Honor, I very much disagree.
Well, that's going to be the scenario likely, so go ahead.
Well, I would just disagree that in any sense that would be an advisory opinion. This is an actual scenario that took place. The court is presented with these orders that have what we view to be erroneous legal conclusions, and in order to reverse those orders, there needs to be, legal findings and, and some direction as to how to do this.
You're saying orders, plural orders.
Yes, Your Honor, plural orders. There's a number of orders. We have, I want to say it's 1, 2, 3, at least 4 orders up on appeal. Really, there's 3 that we're taking an issue with.
Right. But there's a number. So there's a number there of 69,31,757 as of February 27, 2017. Are you telling me then that well,
which he's paid, by the way, as we stand here, because we attempted to get, those proceedings stayed. And
well, then, as to the accounting aspect, is there a number that he was then given after the clerk did his or her accounting and said, okay, I've tallied it all up and here's your number? Is that the number that the judge found as of?
No, the judge directed the clerk to adjust their records, find that he was past due, after the December 2017 hearing. Apparently the clerk did that, and then there was a further motion in 2018 to enforce all of that. And then he wound up paying everything when we weren't able to get a stay from this court.
That was
So
in June 2018?
June
18?
Yes, earlier this year, there was a contempt motion filed in 2018, and that went on, and we tried to get a stay, and eventually he wound up just paying it all as of earlier this year. So I want to say March of this year, prior to a hearing, he made a full payment of what they were seeking. So somehow, we view he's owed money, and quite a substantial amount of money.
So really, today you're thinking whether he was properly found in contempt, there were numbers that he was given that he has now paid, and you think that a proper accounting would suggest that he's entitled to some of that money back because he's overpaid.
Absolutely, Your Honor.
And the proper accounting, wouldn't that again just be going back to the clerk saying, how much did this fella pay to you people in the clerk's office? How much was he supposed to have paid? And if he's paid too much, that's how much is then owed back to him by his ex-wife.
Correct, except for the problem is the process that the trial judge used was fundamentally flawed. And the trial judge accepted testimony from the former wife, from a spreadsheet, from her bank statements as to what she received in direct deposits.
But I don't mean to keep cutting you off, but I mean, and I get what you're arguing, but does that matter at this point in the sense that your fellow knows what he's paid, and he would have paid it all to the clerk? And we can again go back to my calculating, saying this is what the total he should have paid when it all was all said and done. How much does you clerk's office show that he's paid? I computed that he should have paid $108,000. If he's paid $112 because he felt, to avoid any incarceration for contempt, if he's paid that amount, and that's what the clerk shows, then he should get money back. Isn't that? I mean, I know we're having academic discussions, but your client probably just wants to say, well, that's great, I just want to know if I get money back.
But that was the evidence before the trial court. The clerk's
I know that. Okay,
accounting
all
was
right,
there.
all right. The judge is wrong. How about that? Let's get off of that schneid for a second. Now we're to the point of the clerk said, what are we going to do? The clerk said he's paid $112. The numbers say he should have paid $108. Therefore, he's overpaid by $4,000. So his ex-wife should pay him back $4,000. And then everybody goes on with their lives. I mean, I know that's not a legal academic debate that we're having about 409.2568 and all that. But how is that not the direct resolution of what we have here? And again, I know he wants to be not held in contempt, because I get all that. We can have that discussion with Apellie's counsel, but I get your argument. You don't have to, I won't beat the dead horse if you won't on that one. Okay? All righty. So,
you're the boss, Judge.
Well, I know that, but I mean, we are, at the end of the day, we're dispute resolution people is what our job is. I mean, we get to put on robes and call ourselves cool names, but that's really, we try to help to get to a resolution of dispute amicably between litigants. And we are we're a little higher than the trial court level, and then there's people obviously above us, and so be it. And we all understand that. But that seems to be...
Here's the added problem.
Okay.
Is that we could find all of that out very easily.
Right.
There has to be a prevailing party in this case.
I know I knew that was the part. You have an attorney fee provision in your agreement that says whoever wins gets fees.
Which is very rare in family law cases.
Different than whether we would say, okay, you got $5 million in the bank and she's got 2 cents in the bank, and so even if you win, who cares? You got money. I kind of, tongue-in-cheek thought that was driving the wheel here to some. I mean, I don't mean that disrespectfully. I understand.
At some point, they become pot committed because so much is owed, and everyone knows that the other side's paying for it.
I mean, I agree. Nobody wants to be held in contempt, so I get all that point, and I think we pragmatically can get to a resolution of he's paid it the right amount or too much or not enough, and then the trial judge figures that part out with your all assistance and comes to a resolution, and maybe you're back here again, or maybe you're tired of seeing us. But then we have to address, okay, who's the winner here, because your actual agreement says whoever wins gets fees, regardless of, the guy who has $800 million in the bank, if he wins, he can get fees from the one who has 100.
Very unusual provision
Yeah, I
in
know,
a family
but
law
they
agreement.
signed up on it. They signed up on it, and so they're bound by what they signed. So I get that. So, the resolution then is if we come to where we're going, then if Lambert writes something that says that, well, who's the winner here?
It's
Good point.
it's a major consideration.
Amen. I got you.
But I think that even if the case goes back to the trial judge, there's the issue of the trial judge needs to know what type of evidence he can consider. And when you've got a Title 4D case, and you've got payments being filtered through the State Disbursement Unit, and Medicaid and cash assistance and these other things are being received, they siphon off some of that. This comes up in my practice all the time. People wondering why, he's supposed to be paying X amount, why am I only get Y amount?
Yeah, I mean, and your position is, okay, look, when she brings her spreadsheet up here and says, I only got this amount of money, that's because she was going through the Title IV through the state,
Correct.
and so whatever money they were receiving from your client, they would take some money out for whatever statutory reasons they're entitled to, and they would give her the net, and so she's coming up in her mind, fairly in her mind, as she sees it, or, logically, and she says, I'm coming up short. And this, what's going on here?
And this comes up all the time in family law, child support, trial court practice cases. And there's nothing from the appellate courts that really addresses this issue of what is substantial competent evidence to show payments made versus payments received, especially in the
You're in your rebuttal time. You can keep talking as much as you want.
Oh, I'm sorry, Your Honor. I will reserve my 3 minutes and 50 seconds.
So that's
let me
great, but
ask
that's
you-
not the issue for us. And so if the court does find that we reverse the contempt order, where does that leave you? Don't you go back and rehash the evidence and have another hearing?
If the court...
Won't the evidence be different if that happens?
It could be, but what's to stop the trial court from doing exactly the same thing that it did before and accepting the former wife's testimony and spreadsheets and bank statements as competent evidence?
I don't
for
understand
payments
why
made?
that would be an issue. I mean, your client's only obligated to pay what he's supposed to pay. If he pays that to the clerk or the registry or the SD, whatever the letters are up in Tallahassee, he pays that, and there's a list of, this is how much he's paid every time here. That comes up to a number, and then, then you can easily compute now what he should have paid, like I've just told you what I think the number is, and maybe it's different, I don't know. Then whatever anybody says, if I'm a trial judge and your guy says, well, I paid an extra 10 grand in cash, or she says, well, I didn't get all that money from Tallahassee. As a trial judge, why would that matter? I'd say, he paid, here's a list what the clerk says, I can get my pencil and paper out and figure out how much he should have paid. That's the number, have a nice day. I mean, I know that's...
I agree, and that's what should have happened.
Well, okay, well, and it didn't, but if we write something that says something like that, then it really, unless there's something that I'm missing here, and I'll certainly Apellie's counsel can fill me in about that seems, I mean, I'm not trying to make this simplistic for anybody, but I mean, you all seem to be litigating forever and ever, and it seems at some point you probably would both, maybe the attorneys as well, but the litigants probably want to go on their way too, to live the rest of their lives in somewhat peace from each other. I mean, I know they still have children together, but they're adult children, and they're,
I agree.
Okay.
Thank you,
All
Your
right.
Honor.
Thank you,
Reserve the
counsel.
balance.
Sure.
Morning, Michelle Mulca on behalf of the Apellie.
I'm sorry, I could not hear you. What'd you say?
Michelle Mulca on behalf of the Apellie, and feel free to tell me that I'm not being loud enough. It's actually a common thing.
I'm sorry, I'm sorry, maybe I'm missing.
I said, feel free to tell me that I'm not being loud enough because I hear that a lot.
There we go.
So perfect.
I wasn't trying to be funny there. Okay, I did, go ahead.
I was going to ask Mr. Sudbury, what is the Family Wizard, or what, is that a system that Bavard has or something?
No, our Family Wizard is actually an application that anyone can use.
Anybody can use it?
And then each party normally pays about $100 per year. And it
Okay.
has a calendaring function. You get messages on your phone. So it's basically an all control where you can make payments through it. You can schedule things. You can share calendars. You can message regarding specific topics, and it makes it much more convenient and easy for the court to be able to just have a password and be able to log in and see everything that the parties have communicated to each other, when they communicated it, and what the timeliness of it was.
Cool. I guess trial courts are using that now quite often?
That and My Talking Parents are the two popular ones. My Talking Parents is one that is actually free of cost. There's a version that's free of cost. My Family Wizard seems to be much more all-inclusive and all-dressing, but it is $100 per party per year.
That's very nice.
Let me steal your thunder as well a little bit, like I stole Mr. Sudbury's. And you heard, kind of what my,
Yes, Your Honor.
view was of things. Do you agree there's a finite amount he should have paid from January 1 until the last child aged up, right?
Yes, Your Honor.
Okay. And he made whatever payments he made through the registry of the court or the Tallahassee, SDSU, whatever it's called, right?
Yes, the disbursement unit, yes,
So,
Your Honor.
I mean, everybody's respective testimony aside, if he made payments through that, then it should be readily computable you should have paid $108,000 in alimony and child support through the years, and you paid $105 or you paid $109, and therefore there's either money still owed or money overpaid, or he got it right on the nose, and setting aside whether he should or shouldn't be held in contempt, because we are in one of the rare cases where we're looking forward, that we're not on continuing child support, and we're looking at
How to resolve the matter.
How do we resolve it? And I get Mr. Sudbury's concern about the statute and the interpretation, whether the judge should or shouldn't have done that, and that he would like an opinion, and we have jurisdictional issues about whether we can write advisory opinions about that ain't right or shouldn't have done that. I mean, what's done is done, what's paid is paid, what's owed is owed, and it should be readily computable. Is that fair?
Your Honor, I would absolutely agree with that. I think part of the puzzle would involve Mr. Robinson producing what he's paid, and that way we're not just relying on the clerk's records, which he testified that they said that he made an overpayment, that they made a miscalculation, and that they adjusted it, and that's in the record, that the clerk actually at one point in time said that, hey, you've paid too much, oh wait, let's adjust it.
Well, I mean, I get that his argument that he said, I stopped making child support payments for a period of time because the clerk said I had a credit from overpayment of alimony, so he said pragmatically, I'm just not going to pay until, the meter runs, until my credit's gone, then I'll restart. I mean, that was kind of his argument, and that led to some angst below.
Right.
Okay, but over and above that, whether he should or shouldn't have gotten a credit, isn't that somewhat immaterial to today's resolution? Because he either paid money or didn't pay money. The clerk should or should not have given a credit. The clerk's office should show he's made all these payments of X number of dollars, and maybe we were wrong for giving him a credit, but still at the end of the day, he should have paid $108, and he either did or he didn't, isn't?
I absolutely agree, Your Honor, and there is no but. I just believe.
Okay, well, I was all right, I didn't mean to jump ahead here, but.
No, I just believe that it might be beneficial if he could show what he paid, because the clerk did change their amounts.
Well, I mean, it kind of begged the question when I was reading the record, saying, okay, Mr. Robinson, you go to the clerk's office and they say, hey, you've got a $4,400 or $4,600 credit. Did anybody ask him at the hearing saying, did you actually pay $4,600 too much? Did you write a check too much because of whatever? You were a nice guy that day? But I mean, it seemed like, if I'm understood your side, is there's a credit that showed up, we don't know why, and it shouldn't be sacrosanct here. There ought to be some explanation as to why there's a credit. But still, I know you're all advocates. From our standpoint, we're saying, okay, still, at the end of the day, there was a finite number to pay, and he paid all the payments through the clerk. They should be able to tally it up, and A plus B equals you owe nothing, you owe something, or she owes you. And then you all have one more hearing perhaps with the judge, or you work it out saying, okay, what are we going to do about this $2,000 overpayment or $2,000 underpayment, and can we get this over with and get on our way? I mean,
Absolutely
isn't that how this case resolves? And whether he's in contempt or not, if I'm understanding his brief, and he's pretty much saying, I've paid whatever I was ordered to pay, I just don't think I should be held in contempt.
Well, Your Honor, I would argue that he's stated that he paid whatever the clerk told him to pay, not what he was ordered to pay. And
Okay.
there is a distinct difference in those two.
Can you tell us what the court ordered him to pay?
In which, if you don't mind clarifying, in which order?
So in the partial temporary order from November 2nd, 2015,
The one that said that he needed to pay the 2015 medical expenses?
and then wasn't there additional language that said periodic payments, the monthly payments? So my question is, was the defendant on notice?
In November or the October 2015, I apologize.
Well, I think, I'm sorry, go
There's
ahead.
another one, July 26, 2016.
Your Honor, I believe the only one that doesn't specifically address amounts, so there's one, and I apologize as I don't readily know all the different orders off the top of my head. I do believe that there's ones addressing taxes, there's ones addressing different figures for different amounts. I believe the child support one is specifically relating to what he was past due on, and then the accounting of what we could verify based on Ms. Robinson's records.
Well, I mean, what some of the angst is, there's a November 2 order that says you need to pay the medical bills, and you've gotten copies of all that. And then there became a later order that's part of the 17-1109 appeal that said, okay, you were supposed to pay $3155.07 for the 2015 medical expenses, and he's saying, I shouldn't be held in contempt for not paying that because the order that you told me to pay it didn't tell me the number. And oh, by the way, we were at a hearing and we didn't get to finish, so I can't be held in contempt when I didn't get to put on my evidence to contest some of those numbers. But what he's saying in his initial brief, as I understood, and I thought Mr. Sudbury told this, and he's saying, look, we're past that. I'm okay with the number, or I accept the number. I mean, not okay. I accept the number. I just shouldn't have a contempt thing hanging over my head because orders can't be vague. Orders have to say, you do this by such and such a date, and if you don't do this, there's ramifications through civil contempt. And we can, but again, in the big picture of what we're talking about, that's almost neither here or there at this point.
No, Your Honor, and I would absolutely agree the children are now past the age of 18,
Right,
so it's just a matter of
And
resolving
it doesn't
the
matter
issue.
really to your client whether he's adjudicated in contempt or not.
It does, as he paid her attorney's fees for having to litigate that and receive that money.
Well, maybe he's arguing to get paid. It says, I didn't interpret that in his brief or his argument. Maybe I just didn't ask him about, well, do I get to be reimbursed my attorney fees as well? I know he was ordered to pay $100,000 in that one, and then I think like 32 or something later on in another order.
Correct, Your Honor.
But the $1,000 was to the contempt order vis-a-vis the 2015 medical expenses, right?
Correct, Your Honor, and if I may respond to
Yes, ma'am.
that specific incident, and I apologize if that was Your Honor's question, I was not quite on, and I appreciate the clarification. The contempt was found on the basis that it was already in the marital settlement agreement that he was to pay half directly to her for the medical expenses. In 2015, at that hearing, he testified that he did receive those medical bills for 2015, but he hasn't paid them until the court told him when and where, I believe was the exact words in the transcript. So he testified to his ability to pay. The court further ordered him in that specific order to go ahead and pay within 90 days and gave him 90 days to do so in case he wanted to contact the doctor's offices and dispute any amount. Ultimately, if he believed some of those bills to be fraudulent, he could have filed a motion and preserved those issues and tried to have the court adjudicate that those are not something that he should be paying. If he was not willfully and knowingly violating that court order, he would have paid all of the ones that he had verified, that he had made efforts on, and that he had indeed believed that he owed.
But I
So-
thought that at the hearing, though, you presented we're going to go through each one of these
Binder.
bills, and the judge said, wait, the clock, we're running out of time here, and we're going to come back and do it. And I know Judge Polk entered an order, and you seem to be saying, well, if
the
you don't want to be held in contempt, you should have filed another motion or something like that.
No, I believe as to the 2015 bills, there was testimony on the record regarding that he had received them and that he just was not paying them. So those are ones that he testified that he received prior hand. He was specifically not paying those, and that's why Judge Polk, I believe, ruled that he is to go ahead and pay those medical bills with time to verify that those are actually spent.
Okay, but from a contempt standpoint, I mean, if you say, I know I owe forget about your scenario, I know I owe child support, I don't know how much, and the judge says, well, it's 5 o'clock, we got to go, just bring your child support current and we'll call, we'll figure it out. but there's not a number that says this is what you need to pay, and then you're held in contempt again because you haven't brought your child support current, but there wasn't a number that says to be current is this. Isn't that problematic under my hypothetical?
It would be problematic, except for if you were acting in good faith in regards to that order and you didn't quite understand it because you didn't have the figure, you would make the continuing moving forward payments. You would make the payments that you could yourself independently verify, which he had the medical records. So those child support, the amounts past due, those are not the ones that we were asking him to pay so much as the ones for just 2015, which is why the court specifically reserved on the other ones and was to hold hearing later.
Well, let me ask, in the context if we write an opinion about what's going on here, the numbers that were actually determined by the judge for whatever reason, I know there was there was one order and paid the taxes, paid pre-2015 medical expenses. Those combined are about $11,000 to pay the $3155.07 from the 2015 medical. Is that all actually done, as far as you know?
To my understanding, yes. As of a few months ago this year, he's current on all obligations, to my knowledge.
All right. So, and the child, Emmy, I believe, is the youngest child. She's out of high school. So, again, my observation from the record is that the meter has stopped, and I don't mean that disrespect. So we're working backwards now.
Correct, Your Honor.
Okay, is there some money still owed, or what did he overpay? And the judge did direct an accounting to be done.
Correct, Your Honor.
And is it an incorrect analysis to simply say, judge below, circuit judge, here's how much he should have paid, just about child support and alimony, here's how much he should have paid, here's how much the clerk of court's records show that he paid directly. That should be an easy computation, and that should then end these people's involvement regarding alimony, child support, and medical expenses. Is that fair?
Your Honor, I believe that the case law suggests that the burden is on the person paying the amounts to prove that he actually paid those amounts, not the person receiving the monies.
I'm not, maybe I misstate. I'm not saying it's a burden on you, but I'm just saying,
No,
you're all in front of us. You want us to write an opinion or do something about this consolidated appeal. So if we say, look, here seems to be the easiest way to figure it out. Yes, the ex-husband, he has to show he paid. If he comes forward and he says, well, I paid $10,000 cash on the side, that would be problematic. If he said, all my payments are made through the depository, and then that depository will show what he paid, right?
Which, Your Honor, let me preface this by saying I do have faith in the depository.
Oh, okay.
However, I do believe that we are all human, we all make mistakes, and I don't believe that solely relying on the depository would be in the benefit of the clients.
What would you say then? So if he comes in and says, Judge, I'm moving for a $2,000 refund from your client because the depository says that I made all these payments and I should have only paid this. I paid $110, I should have only paid $108. I would like $2,000 back. You're saying that would not be good enough proof? He would need to show the checks that he used or something?
No, I'm saying that he needs to actually know what he paid. I don't believe he knows what he paid.
Well, I mean, that's a saying. I would assume, I would look at my checks over whatever payments I've made over the years saying, I believe I've paid X number of dollars for utilities or whatever over the years, but I wouldn't have independent recollection of it other than I'd say, well, I would have to look at my checks, which I paid every month.
Right, and I agree with that point. If he can collect documentation and refresh his memory, however he needs to do it.
Was there some issue about the deposit? Was the depository, there was an error, wasn't there, or at least you thought there was?
Yes, Your Honor.
You really didn't have the credit, probably, is what was part of it?
Yes, and my concern is that the depository, because I have not actually reviewed it personally since the new orders came out, and I apologize for lack of preparation in that regard. However, it's my understanding that the depository had at least one admitted error by Mr. Robinson. Yeah. And what is to say that there's not more than one error? So the burden is on him to prove that he actually paid those monies. The depository is there to assist him in that process and to help keep track of it. But because we already fundamentally know that there's been one error, I would request that we don't just rely on the depository, but we gather additional evidence. And
Can't I mean, but that's the judges, trial judges. I mean,
And I
if he-
agree.
If he comes in, Mr. Robinson says, look, I made these payments, the depository says this, I paid what the depository said, I think that actually then, if you wanted to contest it, that would somehow shift the burden back to you. I mean, the trial judge, in other words, my point being is the trial judge could accept that as competent, substantial testimony and saying, okay, here's what he said he's paid, here's what he should have paid, the proof from the neutral depository says that's how much he paid, I'm going to accept that as what has been paid. You obviously then have a chance to present your own evidence in response to that, but
Correct, Your
in other
Honor.
words, he doesn't have to, you don't get to necessarily tell him how he needs to best prove his case.
And I completely agree with that, Your Honor, which I believed I was answering your question on whether or not Your Honors could do that calculation, and I don't believe that you'd have the evidence to do that.
Well, no, I mean, we could write something that says
Right.
there's a finite number of money he's paid, he's supposed to pay it through the clerk. This seems like it's a readily determinable amount as to whether there's overpayment, underpayment, or paid on the nose. Therefore, you did order trial judge to have this accounting done. You then entered these other orders about how much was owed or not owed. Apparently, everything has been paid. Now it's an issue of whether there's a refund's due or if there's still anything owed. Everything's been paid under your court order, the numbers that you determined, Judge.
Correct, Your Honor, and I would say in response to that I believe that the trial judge already did exactly what you're suggesting based upon opposing counsel statements back in 2018, which did account for the monies.
In 2018?
I believe so.
So the number of 693157,
I believe that there was an accounting received back from the clerk, and then at that point in time, they held another ruling, a subsequent ruling that is not before the court.
oh, it's not?
No.
Oh, okay, that's not, okay.
Correct,
I-
correct.
I thought I was
Correct.
maybe missing something here. I was thinking.
No.
I've unearthed the resolution here.
I apologize that.
No, but I appreciate that, and I understand if it's not part of the record, but I also don't want to waste everybody's time either. I mean,
Correct,
if
Your
you're
Honor.
saying that at some point the judge did, over and above the orders that are before us today, the judge actually did get his accounting that he requested, and that gave you all a number.
I believe so, Your Honor. Like I said,
Sudbury doesn't think so. But in any event, he's got rebuttal time, and he can tell me about that. So.
ultimately, Your Honor,
You understand, I don't want to make you all go back for another hearing if that's already been done, but if it hasn't been done, then you ought to get this done finally once and for all so that
which
you
our
can.
clients would greatly appreciate that. And
No, and we're trying,
Meantime-
and I see that as the way to go here,
Right.
frankly, for the most part.
Yes, no, absolutely. I would just like to say that there are court orders that Mr. Robinson did not comply with, and therefore we do request that you find him in contempt.
Well, let me ask this here, as to the attorney fee issue, you have that unique provision in the agreement that says the winner gets fees. Okay, so if we enter,
Your Honor,
yes, the question is if we vacate the order of contempt, is he the winner even if we send it back and you all end up getting money because it was an underpayment? So do we even know who the winner would be?
I don't believe that we would.
All right.
Does the panel have any further questions?
Anything else? Okay, thank you very much. Okay, Mr. Sudbury, 347 left, sir.
Yes, Your Honor. I wanted to point out a couple of things. There was an issue as to where the credit balance came from, which came up in counsel's argument. And that is in my brief in the Statement of Facts, page 14 and 15 of my brief. And both parties testified consistently. I think the only place where they were consistent. The former wife stated that she received a payment of $16,472.17 in May 2014. I go on that page to state, to quote the respondent, or my client, stating that he, once he gained employment and everything, he started making these payments. He had this payment plan with the clerk. He then got a coupon from the clerk saying, you owe $16,000 and some odd dollars. He then paid it in full. And then the clerk later identified that there was an overpayment. They corrected their records, and that's where the overpayment came from.
From the 2014
From
payment.
2014, before any of this started, because none of this started until the summer of
Because his
2015.
alimony wouldn't have ended until sometime in 2016, wouldn't it?
I mean, off the top of my head, I'm not sure about that, but
Well, it's if it started in 2000, maybe 2015, because it's 54 months, so 4.5
Yes.
years, so 12, 13, 14, so middle of 2016.
and that's where the credit came from. And then
So he got a credit from a payment 2 years earlier, an overpayment 2 years earlier? then?
2014, that there was, the clerk then gave this credit, and that's where the payments stopped, because the clerk is telling him he doesn't owe anything. And then on the copies of the medical bills from the first hearing, October 2015 to summer 2016, he was disputing the medical necessity of a lot of these bills. There's orthodontics and everything, and so that he never got a chance to present that, which is why he's not making these payments, because it's uncertain even which ones he's supposed to pay.
He's saying, I got the bills, but I don't, I don't know that I should pay for everything
So
because,
is he going back to this, assuming, for argument's sake, that the order is vacated, is he going back and to argue that we
No.
don't need the braces?
Not at this point. He's beyond that.
you said that in your brief.
Correct. I said that in my brief, and he's made those payments. He's, for all intents and purposes, waived those arguments.
Let's go forward. I just
Exactly.
don't want to have a contempt over it.
Exactly. And then there's the attorney's fee issue. Counsel is correct. There were attorney's fees ordered as part of some of these orders.
Right.
We're asking those orders to be vacated. Those attorney's fees should be readdressed in the lower court. We view that that would be an issue to be addressed with the lower court, given that that was part of the order predicated on the correctness of the order.
So he's paid those, but he thinks
Has
that
paid those. He thinks he's owed those back.
Owed those back. I got you.
And then as to the burden being on the payor, I think that that's a very troubling statement from Apellie. They have come to the court suggesting contempt when the clerk's own records, the depository's records, suggest that my client is in compliance. How is it proper to, okay, we don't agree with the clerk's records, but it's your job to prove, our case that we haven't made against you.
Well, I mean, from a burden of, the person who moves for contempt has the burden of showing that the other party's in contempt. And so they have, if they make that prima facie showing, then obviously then the person who does not want to be held in contempt has the ability to say, well, I'm going to put on evidence to say why I'm in compliance, or if I'm not, why I'm not willfully non-compliant.
Your Honor, may I request 30 extra seconds?
Yeah, go ahead.
Correct. And so what I think happened here is they did exactly that. He testified to what he did. They obtained this clerk's accounting. They presented the accounting to the trial judge. The trial judge took judicial notice of that accounting and then disregarded it and accepted the wife's testimony about her bank statements. So with that, I would conclude my argument and respectfully ask the court to reverse the lower tribunal.
Okay, thank you, counsels, appreciate it.